Okay, so I think we can start. Welcome, everyone. We have today an extraordinary panel to talk about the Unión Hidalgo case. 5 months ago or so, ProDESC, a Mexican NGO, together with the European Center for Constitutional and Human Rights, brought a case, a civil lawsuit in Paris, urging Electricité de France, a French company, to abide by international standards and national standards on human rights in relation to environmental protection and protection of indigenous community living in Unión Hidalgo in the state of Oaxaca in Mexico. And we have 3 people today with us, 3 women with us, who are going to tell us more about the case and why this particular case matters and what it means. Let me introduce first of all the panel that we have today. We have first of all, Alejandra Garcia. Alejandra is founder and executive director of the Mexican NGO ProDESC. ProDESC was founded in 2005 and is an organization that works for economic, social, and cultural rights in Mexico. They use community education and organizing. They do corporate research, do human rights litigation, and policy advocacy. Alejandra is also the 2014 laureate of the Martin and Als Award for Human Rights Defenders, a very prestigious award. Secondly, we have Miriam Sage-Mas, who is a qualified lawyer and vice legal director at the European Center for Constitutional and Human Rights based in Berlin, where she leads the Business and Human Rights Program. Miriam has worked on various cases against corporations related to exploitation of workers in Bangladesh and Pakistan, and against arms trading companies. Miriam is also a lecturer at the Free University of Berlin. And then thirdly, we have Tara Van Hoom, my colleague at the School of Law and the Human Rights Center. Tara, she's a lecturer here at Essex. She is also the co-president of the Global Business and Human Rights Scholars Association and sits on the editorial board of Business and Human Rights Journal. She's one of the leaders at our Essex Human Rights Center Business and Human Rights Program, through which Tara advises states, intergovernmental organizations, NGOs, and businesses on issues related to business, investment, and human rights. Alejandra, Miriam, and Tara, in this order, are going to talk about the case of Unión Hidalgo, the Mexican case Unión Hidalgo in France, and the significance of this case. Alejandra is going to talk about the ProDESC, or the experience that ProDESC has working on integral defense and steps for domestic litigation and transnational litigation. And she's also going to reflect about engaging with the local community, the Mexican community in Unión Hidalgo, in this case in France. Then secondly, we're going to hear from Miriam, who is going to tell us about this specific French piece of legislation, the Loi de Vigilance, and how they're using it in France and the specific details of the legal proceedings there. And then Tara is going to help us contextualize it in the wider context of efforts internationally to hold corporations to account in relation to human rights. So I hope you enjoyed. We have about nearly 1.5 hours of exciting information and analysis about business and human rights. And I will keep quiet now, and I leave the floor to Alejandra, please. Thank you.
Thank you, Koldo, for this space, and thank you for organizing everything very, very smoothly. First of all, I would like to, of course, thank the University of Essex for this invitation and the organization of the lecture. I had the pleasure to meet Koldo Kasla some months ago and discover the interesting work and experience he has on human rights, not only in the academia, which is very important, but also in civil society organizations in Europe. I am also glad to be here with my dear colleague Miriam Sage-Mas from the European Center for Constitutional and Human Rights. with whom ProDESC has worked for long now. And finally, let me say I am honored and a little bit nervous to be sharing the table with Dr. Tara Van Ho, an expert on business and human rights that I really admire and follow on the Twitter and all the platforms that she's intervening, because all the work that she has been doing is really important and is very clear, related to human rights and also the intervention of businesses on the life of people. Not only, it is not only about business, but it is principally about human rights. So I will start by briefly introducing myself. Goldo did a very good work, but I will just say that I am a Mexican lawyer and a human rights defender. I am the executive director of ProDESC, which is the project on economic, social, and cultural rights. And we had been working principally in two main areas: the rights to land, territory, and natural resources of indigenous communities, and labor, human rights of workers, especially women. At ProDESC, we work with a comprehensive approach that considers the defense of human rights through strategic litigation, strategic communication, research, to advocate in decision-making spaces, and strengthening human rights defenders as well as their groups and communities. Today, along with my colleague Miriam Sagemas, we will be presenting the Unión Hidalgo case, which is an indigenous community from the state of Oaxaca in Mexico. I will start by sharing a small video which gives you a quick overview of the context, the issues, and the community claims, which for ProDESC is very important to bring to these spaces, not only the analysis and the legal strategy and the impact that we are trying to do, but also bring the real experience of communities facing transnational corporations. Well, as you will see in the video, Unión Hidalgo is an agrarian and indigenous community in southern Mexico, which is located in the Istmo of Tehuantepec. This region became very popular for wind farm projects because it has an excellent potential of wind resources. Well, I was saying that almost 95% of all wind electricity in Mexico is generated in this region. This area, the state of Oaxaca, Chiapas, and Guerrero, is also home to a variety of indigenous people who have kept their culture and languages, creating unique models of organization through agrarian assemblies. However, ongoing disposition of land that started during the colonial rule and continue to this very day have produced high levels of poverty. For us, the disposition of land, which is a central part of business models, has clear winners, which are transnational corporations and specific interests within the states, and clear losers, the indigenous communities. The construction of over 30 wind parks in the region has been highly controversial, and the promoters, the companies, and the government have failed to address violations of economic, social, and cultural rights. The community of Unión Hidalgo is now surrounded by several wind farms. As the human rights defender Oscar Marin says in the video, besides these new activities have not brought a single benefit to the community. In the current case, we want to present you the community of Unión Hidalgo. It is defending its land, territory, and natural resources from the French company Electricité de France, which pretends to build the biggest wind farm in Latin America named Gunaa Sicarú. From ProDESC, we have identified at least 4 main points where the human rights of the community had been violated. The first one is the right to a free, prior, and informed consent. Mexico has ratified the ILO 169 convention, and for the Mexican law, these treaties are binding. However, the Mexican authorities had provided EDF with energy permissions and other administrative procedures without the community even knowing the project, let alone having consented to it. This is a clear evidence of the corporate capture of the state. ProDESC and the community managed a landmark resolution from a Mexican judge that mandated the Mexican state to implement a free, prior, and informed consultation. Since then, the process led by the state and the company has demonstrated huge irregularities, indicating interest in concluding the consultation as fast as possible to begin the construction of the wind park. These actors have even pushed authorities to call for assemblies regardless of the COVID-19 pandemic. This could put the community in an imminent risk considering the age of people who live there. In a strange twist of events, the current Mexican government plans to change the energy law. And today we have a new twist because with this new energy law the government is trying to discourage the construction of renewable energy projects due to the new national plan to strengthen the Mexican oil and electricity public companies. However, companies already started to challenge the law, and several federal judges granted the amparo to these corporations. And today the Mexican president announced that if law is not passed, he's going to introduce a constitutional reform, which will make the landscape more complicated for all the different actors. The second is the denial of the collective property of land in which EDF plans to build the wind park. Most Mexican communities have a collective property of the land and not individual properties. Therefore, the definition of what to do in collective lands must be decided by a community assembly, a company also for the agrarian authorities. Electricité de France has been notified by a Mexican judge of these specific characteristics of the land in Unión Hidalgo. However, the company continues to act as if the land was owned by individuals. These actions are manipulative and generate conflict between people from the community, destroying the traditional forms of organization and decision-making. Our third concern is the violation of the right to defend human rights. The state and the company have criminalized and threatened human rights defenders. Human rights defenders can attend the consultation assemblies without receiving threats. ProDESC and the community have documented serious cases of kidnap attempts and specific death threats. Under the false narrative that the wind park will provide progress to the community, human rights defenders are pointed as anti-development people, which then denies them of their communitarian roots and relationships. Some people even consider these human rights defenders as anti-climate change and consider that renewable energy projects must be built at any cost. The reality today in Unión Hidalgo is that human rights defenders from the community risk their physical, mental, and moral integrity just because they claim the right to a free, prior, and informed consultation. Finally, a fourth observation is the denial of any responsibility from EDF to the violation of human rights in Unión Hidalgo. Due to their corporate activities, EDF has consistently avoided any communications in good faith with the community. In the very few communications they had, EDF has discredited community's representatives and has pointed out that the responsibility falls on the Mexican authorities, even though they are obligated to the duty of vigilance in accordance with the French law. Unfortunately, ProDESC experience has shown that EDF behavior in Unión Hidalgo is not an isolated case, but rather part of the business model that most transnational corporations have implemented during decades. This is important to point out as the European Union and several countries in Europe and Latin America are discussing mandatory human rights due diligence. The discussion must go further, understanding that a voluntary corporate social responsibility approach is not enough to promote and defend human rights. Ultimately, they must focus on how to prevent these human rights violations and not to wait for the inevitable to happen. Considering the transnational character of this case, a Mexican community whose rights are being violated by a French corporation, ProDESC has carried out a series of activities in Mexico to defend the community. These include strategic litigation, advocacy with the Mexican federal and local governments, strengthening the collective groups in the community, and setting up a communication counter-narrative to position how important it is to defend human rights. Transnational activities were also carried out with UN special rapporteurs, with possible investors of the project, and with European politicians, among others. However, ProDESC needed a counterpart in Europe to use legal procedures. That is how the partnership with the European Center for Constitutional and Human Rights happened. I will let Miriam mention the joint specific steps taken in Europe to defend the community, not only the presentation of the litigation using the French corporate duty of vigilance law, but also our prior experience with the French National Contact Point. ProDESC knows it is a challenges focused to talk about renewable energies and human rights violations. However, human rights violations do happen, and the community of Unión Hidalgo is a clear example of it. Renewable energy is presented as the future of mankind, and for that is all good. Yet we believe that the construction of a new development model does not mean that there are people who need to suffer sacrifices so that everyone else can be safe. A green transition without a human rights approach can be as harmful to the communities as a fossil fuel approach. That is another point that I would like to stress further in this talk, because we believe that joining forces with the community is a more sustainable way to development than imposing and discrediting people for the economic wealth of a few. Thank you very much. And I will leave the floor for my colleagues. Thank you.
Thanks very much, Alejandra. I believe we have the video ready. So Miriam, do you mind holding on for a second? And we have 2 minutes now to watch the video, if you don't mind.
¿Qué es lo que más extraño que ya no hay ahora? Pues la tranquilidad de mi pueblo. El salir siempre con ese miedo de que probablemente ya no regresemos. El temor de lo que le pueda pasar a mis hijos. Tengo 2 hijos, 2 nietas, y que ya no vean a Unión Hidalgo como lo vi yo. Que ya todo haya cambiado, que ya no haya paz, que ya no haya esa tranquilidad.
Existe una ley en Francia de que no se puede utilizar la corrupción como método para imponer un proyecto, para imponerse, que todas las empresas francesas se tienen que ajustarse a esa ley. Pero EDF, Electricité de France, no está respetando esa ley, cuando menos aquí en Unión Hidalgo, en mi comunidad. Y eso duele. Lo que yo le pediría a los ciudadanos franceses, a todos ellos que vean, que analicen nuestra situación, que se pongan tantito de este lado para que se sientan ellos, para que vean ellos esto que estamos padeciendo y que tomen la decisión de apoyar este movimiento. No es por otra cosa, por otra causa más que el respeto a los derechos indígenas, el respeto al medio ambiente, porque EDF, Electricité de France, ha recurrido a los actos de corrupción para escondernos todas las informaciones que nosotros quisiéramos saber.
Thank you, Coldo.
Thank you.
Yes, thank you. Also, yes, thank you to Essex University for the invitation. Thank you, Alejandra, for once again having being here with me. Thank you. I'm also very honored to speak about this collaboration today. So I will start a bit to again explain sort of ECCHR's work and our perspective to the case, and then I'll speak more specifically on the case that we've brought in France, together with ProDESC and of course with Unión Hidalgo and French lawyers. So ECCHR, we are a human rights organization that uses legal tools to address human rights abuses, usually abroad. So we work with persons negatively affected by human rights abuses, and we seek to find ways to hold those accountable who are responsible for the human rights violation. As an organization based in Europe, we primarily see the legitimacy of our work that in addressing and challenging the role of European actors in human rights violations, and in particularly the role of European corporate actors. It is central for us, or a central piece of our methodology is that we seek to collaborate with communities and affected workers usually in production countries. And we seek to find the common goals between the national and local struggles and our goal, which is, shortly to put it in short terms, to hold the companies responsible behind the local human rights abuses, or that are connected to the human rights abuse, or that are contributing to the local human rights abuses. And for us, it is very important to have partner organizations and that have a clear agenda, their own clear agenda, their own goals, and so that we can actually collaborate and work together and see, how do these, how does our goal or how do our aims fit together with those of the community, and is there something that we can contribute really to the community struggle? In particular, we're trying to find and use legal tools as strategic and innovatively as possible to enable communities and workers to bring their claims into European courts and sort of to bring the struggles back home to the corporation's headquarters. And for that, we find it particularly important, and I think this is also what is remarkable about Unión Hidalgo but also, of course, ProDESC, is that this has been possible to have very much an eyes level exchange on what are the political goals and how can we contribute to these, even in light of all the discrepancies and obviously the privilege that comes with being located in Europe, right? And so I'm very glad about this cooperation. And in general, I think what is also you can see in this case, but in general, what we face in our work is that there are hardly any classic procedures in place that you can find in other, when it comes to holding corporations to account for human rights and abuses, than if you look at other classic fields of human rights law. So be it migration, be it international crimes, you have very clear procedures, you have courts that have competence, and then you will fight about the application of the laws, you will fight about theories of law to be applied. But in the field of business human rights, you're already lacking actually procedural avenues. And so the EDF case is also really emblematic of this lack of corporate accountability routes, and sort of the little hope we have that this may change eventually. So because when we started the collaboration, at first, it was very clear that this case, and especially the specific claim and the goal of the community to protect their land and to claim their rights to free, prior, informed consent, that there really would not be a real legal route for this in France, except using the OECD guidelines, which is a soft law procedure, which is very voluntary and has no enforcement mechanism. And so, well, in absence of anything else, we decided that, ProDESC and Unión Hidalgo decided that the OECD guidelines would be an option they need to take. After a year of being into the procedure, they also decided to leave this because there's really no point, and you could see all the inefficiencies and that there are, and anything negative you could say about the OECD procedures really realized in this case. It was handled poorly, there were delay tactics, you know, the company really didn't commit to anything, and I think Alejandra can be, you know, be in more detail about this actually. So we then, with France being the first country in Europe implementing a mandatory human rights due diligence law. I think the French wouldn't say it's a due diligence law, but I'll for now keep it at this. The loi de vigilance, which there was now then a route to be taken. And I think this is why we decided this is, you know, we're going to use this because it's hard law and the claims can be brought again. Before I go into more details of the case and how and what we argued there, I wanted to say that another important aspect also for us to be involved in this case is that this case is also emblematic of the way in which European companies are involved in human rights violations when it comes to the extraction of natural resources. You can see that actually resource extraction and energy production is a very land-intensive projects, and therefore carry a high risk of violating people's, and especially indigenous persons' rights to land, but also right to housing, right to food, healthy environment. And it's also emblematic in the way how a company that keeps on implementing a project despite the obvious human rights risks, here to the free, prior, informed consent of indigenous peoples, but also to their to the threats they are receiving as the conflicts around the project are escalating. But if a company simply ignores those risks that are posed also to the security of human rights defenders, and just keeps on continuing, how this exacerbates local dynamics and human rights threats and human rights violations. And while, you know, in implementing and keep on implementing the project, EDF always hide it behind sort of the state responsibilities, Mexican state's responsibilities, but also behind its corporate structure, as the headquarters obviously is not directly involved. It's a subsidiary, and then again contractual partners of this subsidiary that are really causing the problems. So how we've been arguing, or how we've been going using the loi de vigilance, is that we've once claimed that the vigilance plan that the company is obliged to create, and that needs to assess all possible human rights risks that the company is involved in with regards to all of its projects as a company, is that they did not identify the risks of the violation of the free, prior, informed consent of the community Unión Hidalgo, and that they did not identify properly the risks of to the safety of human rights defenders that are opposed to their company's projects. As they did not, we are arguing, as they did not foresee those risks or identify those risks in the creation of their vigilance plans, which means in the creation of their, or in operationalizing their human rights risk assessment, they therefore didn't see any measures to mitigate those risks. So they, they didn't foresee the risks, so they didn't react on those risks. And we say they should have, but they should have foreseen the risks, and they should have done anything to mitigate those risks, because since the initiation of the project, the consultation was led in a way that would not allow community members to really oppose the project or to raise their concern. So there was no real way of no process in place that would ensure that there's a consent given to the project in a free and fully informed manner. As Alejandra explained, the whole setup of this process was so that the tension would escalate so much that simply free, prior, informed consent wasn't possible. And sort of by tolerating and going about and keeping on being involved in this project and simply going step by step into this project involving contractual partners on the ground, creating incentives sort of for community member, giving promises to community members for supporting the project while while sort of discrediting others for being opposed. We felt like this is a clear violation. They actually not only ignored their responsibility to mitigate, but they actually created and contributed to human rights violations. From the procedural point of view, it's possible under this French law to both claim for preventative actions, but also to ask for compensation. So we did both. We said that on one hand, there's the preventative aspect, is that the consultation and the project needs to be halted until EDF has sort of done their risk assessment properly and has adapted their plan de vigilance in accordance and has implemented mitigation efforts. But also we're saying that as the threats have been occurred and there has been damage caused already, that this is also why we are asking for compensation. So it's a twofold claim. We are procedurally, we are waiting for the first hearing of the court in France. It was scheduled for February. It has been postponed. And in that hearing, the question of admissibility, jurisdiction and standing will be discussed, but also requests for evidence taking and the conservatory measures will be discussed. And once those questions are decided, we then will actually move on to the merits of the case. Yeah, so I think one last word is to say, I think this case also clearly shows how there is a need for better regulation, for better avenues for persons negatively affected by corporate actions, by European corporate actions. I think so. This is why the whole discussion, I think that also Tara will be touching upon on mandatory human rights due diligence legislations, both on the EU level but also national levels, are of great importance. Germany is currently debating. There's a law proposal now debated in Parliament, which I think we probably can touch upon in the discussion later on. So thank you.
Thanks very much, Miriam. Before we pass the microphone to Tara, just a reminder to the audience that you have the Q&A function, and feel free to ask your questions or type your questions there, and then after Tara's intervention, we will have the time to discuss them. So Tara, please.
Thanks, Koldo, and thanks to Alejandra and Miriam. I have said this publicly on Twitter, so I'm going to say it again. Like, I'm not actually worthy to be on this panel. It's not just because I'm the least knowledgeable about the case, which is true, but I'm actually like deeply in awe of Alejandra and Miriam and the work that they have done to advance corporate accountability in practice. I usually sit on Twitter and articles and espouse interesting thoughts, I think, but they're the ones who are actually accomplishing the things that I think should happen. So I owe them both a huge personal thank and a huge professional thanks for all that they have done. I want to pick up on something that Miriam said, which is about the lack of real procedural avenues that led to this case. Business and human rights has long been essentially a game of hot potato. For those of you who haven't actually played that game, it's when children take a little item and they pass it around in a circle while music plays. And whenever the music stops, whoever has it is it, right? Like you're out of the game, you've lost. And that's kind of how both companies and states have treated the issue of human rights impacts by businesses, right? Mexico has the hot potato, but they don't want it. So they pass it to EDF to do their responsibility, but EDF doesn't want it either. And so they try to pass it back to Mexico. And those two just keep passing it back and forth in the hope that somebody else will end up eventually taking responsibility, but also hoping that no one actually does take responsibility. And then there's France, just sort of sitting in the circle, and they're not ever supposed to have the hot potato, right? Like essentially they're kind of the music player or an observer, because France isn't there on the ground. France isn't the one who holds direct responsibilities or obligations towards the people in Mexico. And they're not actually actively engaged in this game that EDF and Mexico are playing with the lives of indigenous peoples. But at the last minute, when no one else is going to take it and the music goes winding down, somebody just passes it to France and says, please, you figure it out. You do something here. And essentially, that's actually been the collective groan, desire, plea of the business and human rights community as a whole. Like, dear France, please take responsibility of it for this. And to France's credit, they have. But what I want to talk about today is the fact that, first of all, it never should have gotten to that point. And second of all, France is still standing alone, right? I don't want to keep doing children's games here, but you know, I don't know how many of you also played the Farmer in the Dell, which is where you like choose people you want to hang out with and join hands with, and then somebody stands alone and that's the cheese. And that is France right now when it comes to human rights due diligence. They are still standing alone and they shouldn't be. And so I'm going to call out a bunch of people and a bunch of states and a bunch of companies today for their failure to really take seriously their human rights responsibilities in this area. But I want to start with an acknowledgement of Sherpa, which is the NGO that really helped push forward the French due diligence, their duty of vigilance law, and the French government. I'm going to criticize you as well, but I'm deeply appreciative of the fact that you have adopted this law and that you are leading the way. So let's start with Mexico, because they are under international law, the duty holders. And as Alejandra noted, Mexico has obligations under the ILO Convention 169, which it ratified voluntarily. It has obligations under the ECCHR, the Covenant on Economic, Social, and Cultural Rights, which Mexico voluntarily ratified. It has obligations under the Civil and Political Rights Convention, which Mexico voluntarily ratified. All of those ratifications going back to the 1980s, all of those choices by the Mexican government to pledge to respect the rights of individuals to choose what will happen in their communities and to have a voice and a say in how their communities are going to evolve and what protections they have. But when given the opportunity to fill this, Mexico hasn't actually done so. And it's quite interesting that Mexico has chosen not to do this domestically, right? They aren't doing this. It's not just Unión Hidalgo, right? Like it's actually quite somewhat consistently in Mexico when it comes to energy companies, that they're willing to sort of look the other way on their human rights obligations because it brings in money and it brings in economic development, which we can talk about sometime in the Q&A. And they're not fulfilling those responsibilities, even while at the international level, Mexico has actually done quite a good job in advocating for a business and human rights treaty, right? In pushing forward the notion that we should be working together, states and companies, to advance human rights and respect for human rights in business operations. And here I do want to give credit to Humberto Canto Rivera, who is my friend and colleague, who has been helping Mexico sort of navigate the UN treaty negotiations, but also say like, to Mexico, what are you doing, right? What are you doing that you are taking at the international level a recognition, a deep recognition that each state has an obligation to protect their citizens from human rights harms and to regulate their corporate nationals when they're harming human rights, that there's an obligation there to provide a remedy, an effective remedy for business harms on human rights. And then when you come to this case, all of that disappears. And Mexico is not alone on this. Ecuador is right there with them. All of our business and human rights saviors of states, France and South Africa come along with us on this journey. All of them have really serious, grave human rights violations that are happening domestically because of their corporations' activities, and they're failing to regulate and provide remedies. So if we want to talk about Ecuador, you're still talking about energy companies. If you're talking about South Africa, you're talking about mining companies. And if you're talking about France, you're talking about the whole range of companies involved in racialized discrimination against, particularly against North Africans and also against Muslims as a more general basis. Deep, serious structural issues that they're willing to talk about when they happen in somebody else's country, but they're not willing to deal with when it's coming home. And so Mexico has passed the hot potato to EDF. And what we see with the EDF claims is what we've seen with Shell in Nigeria, is what we've seen with mining companies in Colombia, in Papua New Guinea, in Zambia. It's what we see sort of generally speaking when we talk about energy. And it's really problematic that with this new technology, as Alejandra said, this new technology that's supposed to help transition us into a more secure and sustainable society is now being used to replicate all the failures that we have within the old energy sector, within the oil and gas and mining companies. So what we're seeing are plans that are developed with consultation, a belief by those in capital cities that they know what's best for the rest of the country, so they don't actually need to consult and figure it out. There's this push for expedited and show consultations that never actually change the fundamental design of the underlying activity. There are these efforts to divide communities. So this constant pushing forward, offering of jobs, offering of incentives so that you can pull away portions of the community and create a division so you can say that you have consent without actually getting consent from the population. That is a very common theme that we have within businesses. And it's really problematic that EDF, which has pledged publicly and repeatedly, including in relationship to this case, has pledged to respect human rights, isn't actually taking the steps that are necessary to respect human rights. And then the final component that we have is something Miriam talked about, which is you also get to this diluting and limiting of responsibility by having your headquarters in France and some subsidiary in Mexico handling this with consultations and contractors so that you don't actually have the responsibility sitting with the parent company. You know, we can just pretend that it's somebody different. And poor EDF, poor sweet EDF just got all wrapped up in this and they had no idea. And now they're just trying to make it right. And why won't anyone let them? And I'm sorry if it sounds really sarcastic or if I sound like I'm being unfair to EDF. I'm not, first of all. I'm not being really sarcastic and I'm not being unfair. These kinds of processes and these kinds of activities by these companies are not isolated instances. They are not things that companies cannot anticipate. You know, both Miriam and Alejandra have pointed out that EDF should have been able to foresee this. And they should have, because these are common problems. These are common activities. It is a pattern. How did I know how this case was going to unfold? Because I've seen this case unfold in 40 other countries, in 60 other circumstances. I can almost plot out exactly what EDF is going to say to the French court. And that's a problem. Because if I can do that sitting in Essex, England, it means that EDF could have done that sitting in France. And their subsidiaries could have done that sitting in Mexico. And they chose not to. So they passed the hot potato. And now we are left with France. And I do have a great deal of respect for France for taking this on. But they shouldn't be the only grown-up standing in the room alongside the local population. And they are. And the reason that we really shouldn't have to rely on France, the reason that it's really unfair to the indigenous populations of Mexico that they have to go to France is there's a couple reasons for that. The first is not all of the violations within Mexico have a French connection, let alone to a French connection that's captured by the duty of vigilance law. It's inappropriate that we're relying on France to take care of these issues, because it will be a 1 in 100 case that can actually get there. Second of all, we have to hope that the French court takes seriously the experiences of an indigenous population in Mexico. And take seriously not just their experiences, but their fundamental human rights. The inter-American system is much more progressive on indigenous rights, much more progressive on the free, prior, informed consent than the European court is. They also have other concepts of human rights within the European court's jurisprudence that don't exist within the inter-American court's jurisprudence that don't exist within the European court, right? The notion of a Proyecto de vida being a clear one, how you provide remedies, the interconnectedness of remedies. The inter-American court's jurisprudence, what the indigenous peoples of Mexico are entitled to, is so much broader, so much more robust than what Europeans conceive of when they conceive of human rights. And so going to a French court and asking them to understand why the connection to the land is so deeply valuable to the indigenous populations, it's unfair. It's unfair for the indigenous populations to have to put their faith in a French court to understand it. And it's also unfair for the French court to be asked to do this because it's so beyond their own experience or their own understanding of law. And yet we have to. These cases are cases that are born out of a combination of real responsibility on France for allowing EDF to exist and to carry out activities as it does, and desperation, because no one else is taking the potato. And it's just really inappropriate. And the thing is we've been having these conversations for 50 years. It's been longer than I've been alive, although not by much. But essentially my entire life has been consumed with these conversations at the international level about how companies should be held responsible, and about how do we get companies to do this. And instead, what we have now in the entire landscape of accountability, of real accountability, is we have the French duty of vigilance law. We have a law about child labor in the Netherlands, which requires companies in the Netherlands to do due diligence only on child labor issues. And they can be held accountable if they misrepresent their statements. And that is framed as a consumer protection law. You have the California transparency and reporting requirements, as well as the Dodd-Frank reporting requirements in the United States, and a couple modern slavery act reporting requirements elsewhere, the UK, Australia. All of those are about states or businesses accounting for what they do. It doesn't actually give a right of individuals to challenge when those companies screw up, when they violate human rights. And then we have Germany. Germany has now proposed a due diligence supply chain law. This follows 4 years in which Germany just allowed their companies, actually, I'm not going to apologize to Miriam. I don't think I'm going to say anything that offends her. It's 4 years in which Germany just allowed their companies to figure out for themselves how to do due diligence. And they couldn't even get 40% of the companies to actually do it. Right? So for 4 years, Germany said, figure it out. Like, we trust you. We believe in our company's goodness. They'll do it right. And they couldn't get the numbers. They couldn't get their companies to take this on board. And the response to that is to adopt another law that has no real bite to it. So the law that is currently going through the legal procedure, the legislative procedure in Germany, doesn't contain civil liability for not doing what you said that you were going to do. It doesn't give a right of remediation to the populations. It doesn't give a right if you've been harmed. And there's no criminal accountability either. So there's not really a lot of responsibility there. And then we have the UK, which has recently had 2 Supreme Court cases that have said that where a company holds itself out as taking on a responsibility, it is bound by that responsibility. When I put it like that, doesn't it seem like the most obvious thing that should be true for every company? If you pledge to do something and you fail to do it, you're held responsible for it. If a real harm comes about, right? If I pledge not to hit, and I love Koldo, so I would never actually hit him, but if I pledge not to hit him and then I hit him, shouldn't somebody hold me accountable? Shouldn't Koldo have a right to sort of say like, hey, you're not supposed to hit me? That's part of the bounds of society. That's as far as we've gotten in the UK. I lay out this groundwork because I need you to understand that this case is, first of all, profound, significant, because it actually offers an opportunity for remediation and reparation for a community whose rights have been systematically ignored by both the state and the company. That's significant. It's significant wherever it happens. It is significant here because it's taking the French duty of vigilance law for a test spin, and that's really important. But it's also really problematic that this is where we're at, that this is what the indigenous communities of Mexico have been driven to have to do, is to rely on a French court to understand their experience and to give them reparation. And it's deeply problematic that France continues to be alone within the EU in having adopted these measures. And not just within the EU, but more or less generally internationally. We don't have the kinds of reparations and the kinds of remediation laws that we should have by now. So I'm going to stop there. Thanks, Koldo, again, and thanks, Alejandra and Miriam.
And just like that, we've run out of time. We could be here for much longer. It's been fascinating. I've learned a lot by listening to the three of you. Thanks very much to Miriam and Alejandra and Tara for sharing your knowledge and your ideas with us. Thank you all for attending and for contributing with your questions. And thanks finally to my colleagues, Matt Capes and Katia Al-Hatib, who are in the background, making sure that everything runs smoothly and we make it work. So thanks very much. Stay tuned. More events in the Human Rights series of Essex Human Rights Centre to come. Thank you. Bye-bye.